Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. As we've been profiling paralegal and lawyer bencher candidates, as always, the views and opinions are of the candidates alone, and they don't reflect me, Justice and Pieces, Trias College, or any of the other education institutions or organizations that I'm affiliated with. Today, we have Jasminka joining us. And first of all, thank you so much for taking the time to speak with us. Perhaps you can tell us a little bit more about yourself.
I will. And thank you, JP, for doing all of these interviews with all of the bencher candidates. I really appreciate it. And happy to introduce myself. So my first name is Jasminka. My last name is Kalajdzic. I know that's a mouthful. I don't know how far back I should go, but I'll start with the fact that I'm from Windsor. I spent half my childhood in gritty downtown Windsor, and the other half in a small suburb just outside of Windsor, LaSalle. I am the daughter of immigrants, first generation Canadian. My parents are from the former Yugoslavia. So my late dad, I lost him 22 years ago, it was from Bosnia. My mom is Croatian. And I guess like a lot of lawyers, maybe especially those who come from immigrant families. My parents put a lot of emphasis on education. I ended up being the first person in my extended family to get a post-secondary education. I did a bilingual degree at U of O in English and French literature. And I remember to this day, and I'm in my 50s, so I don't remember a lot anymore, but I do remember how proud my dad was when I graduated from university. And it's why I am notoriously weepy when I attend law school graduations at Windsor, where I'm now teaching. So huge value on education. Ended up going to U of T law with the intention of being an international human rights lawyer. Coincidentally, at the time that I was at U of T, the war in the former Yugo was happening, and all of my extended family was caught in the war, especially in the siege of Sarajevo. So it was a really interesting time to be a law student thinking of a career in international human rights. Ultimately, it was an internship at Human Rights Watch, an unpaid internship at Human Rights Watch in the summer of 2L that convinced me it wasn't the path for me. And so I switched gears and ended up articling at Tories, was hired back in the litigation department. I had a great articling experience, which I know not all law students can say, unfortunately. And then again, I switched gears. So 2 years in, my then fiance, now husband, and I kind of took stock and realized that for lifestyle reasons, we wanted to be back home. Having grown up as a kid without any extended family in Canada, it was really important to me to have, family around me when I had my own kids. So I moved back to Windsor and was hired by Harvey Strasberg to work at his firm, where I did all kinds of civil litigation, but inevitably, of course, did a lot of class action work. So I was fortunate to learn from the pioneer in that area of law. And I did that for 10 years. And then again, switched gears and had caught the bug of teaching when I was a guest speaker in Reem Bahdi, now Dean Bahdi, a tort class, and thought that this was something that I could do and thought I could do well. So I ended up going back to school, U of T, to do my LLM in 2008. And then was ultimately hired at Windsor Law full-time in 2009. And I've been there since, teaching access to justice, class actions, evidence law. So it's a long answer, but there's a reason I wanted to give it to you, because I know at the end of this, you're going to ask me, what advice do I have for your students. And I guess the advice I would give is not to worry about taking, a circuitous path in life. I have had many careers. Lots of twists and turns, and that's okay. You have to sort of be open to change. There's going to be inevitably change in the legal profession. I think because of technology, because of changes in the law, and so on. New doors will open. I mean, class actions, for example, which is now sort of my main area of research, didn't exist practically when I was in law school. The words class action were never mentioned when I was a law student. And now it's one of the busiest legal litigation practices at every major firm. So take chances, and really rewarding things can come your way.
Perfect. So with all of that you've done, and we've traced your history here, next thing that you're looking to add is becoming a bencher for the Law Society. So what kind of brought you into running in this upcoming election?
I have long sort of thought about running for bencher, long as in well before 2019. As an academic, as a former associate dean, and somebody who's taught, thousands of law students and mentored hundreds more, I realized that, the licensing pathways are a big part of the Law Society's mandate. And yet there seemed to be a lot of confusion or misunderstanding about what it is that law schools are doing. And to be frank, I think there's some misconceptions at the law school end on, the role of the Law Society and the Federation of Law Societies when it comes to legal education. So I always thought it would be really helpful to have, at least one or two people with experience in legal education at the table, so to speak, at convocation when it comes to talking about things like articling, the bar exam, et cetera, et cetera. So I didn't run before because I have 3 kids. As I said, it wasn't the right time for me. I am now sadly about to become an empty nester with my youngest going off to university. So it was the right time. And also, the last 4 years at the Law Society sort of galvanized my resolve. It's been, I think, an incredibly dysfunctional 4 years from what I've read in terms of the transcripts of convocation. I've watched the webcasts of convocation. And, like many of your viewers have heard and read about some of the grandstanding and bickering that's gone on at the Law Society. And it's embarrassing, frankly, for the profession. I think it's a risk to our continued ability to regulate ourselves. And so for all of those reasons, I thought it was the right time for me to run. And I was really honored to be invited to be part of the Good Governance Coalition.
Now you bring up sort of those last 4 years, and certainly on the other side they would say, well, no, they can point fingers back at each other of who's responsible for that sort of, as you term, embarrassing situation, right, with what was going on in convocation. And then one of the other things that's pointed at their direction is certainly, well, hey, we don't like the idea of the group of the stop coming together and changing sort of the dynamic of how we elect our benchers. But then you're doing almost the exact same thing. I mean, if not even stronger, with 45 candidates together as the coalition. And it points to, well, can people support you individually, or if they're supporting a group, is that no different than supporting the Full Stop group, just though the ideologies are on one side versus the other? So what would you kind of say in response to all of that?
Well, at least 2 things. So the first is, I completely understand the discomfort that people have with voting for a slate, voting for a coalition, on almost like a party-like system. I get it. And I would have preferred to run as an independent, for everybody to run as an independent. That said, the Stop Stop slate in 2019, started the ball rolling. They introduced the concept in the last election of campaigning as a slate on a single issue at the time, which was eliminating the statement of principles. And so, it was the math that convinced me that this was the only way that we could go back to, some semblance of collegial governance, because the slate was able to attract voters who didn't much care, as far as I can tell, about the individual qualifications of the slate candidates. They were attracted to the message, right? They were attracted to the single issue. And so one vote for, one member of the 22 member slate automatically almost translated into a vote for 22 of them. And that was the result. All 22 were elected, whereas many excellent candidates who are running independently didn't get elected, even though if you total the number of people who voted for non-slate members, it was, double or triple the number of people who voted for the slate. So the same thing could happen again if everybody continued sort of running independently as we've always done, whereas the Full Stop slate now has 35 people running. So it really is the math. Voting for a non-good governance coalition member is a diluted vote, unfortunately, and so you're unlikely to elect, the people you want if you're going to dilute your vote that way. But the other answer, and I hope this one is maybe more palatable to people, is that the individual candidates in the Good Governance Coalition are just excellent people. They're excellent candidates. They've got lots of experience. It's a varied group. It's not all Bay Street, as I think people have been claiming on social media. I think 9 out of the 40 lawyers work in a firm that could, conceivably be construed as a Bay Street firm. Lots of people working in solo practices, small firms, clinics, government, and academic. So I think it's important for people, rather than being turned off by the idea of the Good Governance Coalition, is to actually look at the individual candidate statements. And I hope people will then see that actually, these are really qualified people to be running for bencher. So it's the math and it's the quality of the people.
Now, we don't know in terms of, as you point out, it could be all 40, it could be like 20 and 20, it could be a number of independents, right, in terms of what the actual results will be. But I guess then it goes to the point of afterwards, right? If there's going to be, in terms of the pendulum swinging, let's say the other way, right? I know, for example, you're saying, we're not going to bring back the statement of principles, but if you're kind of going to be voting collectively on issues, maybe in the same vein, that creates another problem just on a different position, right? Is that kind of what could happen afterwards, or is this something that's kind of limited for sort of election sort of resource pooling, so to speak?
It's the latter. It's a necessity for the purposes of the election. But as we've said over and over again, as is said plainly on the Good Governance Coalition website, we are not a voting bloc. We will disband when the election is over. And so there is no commitment. There's no, wink, wink, handshake between us that we will continue voting as a group. I wouldn't have signed up if that was the case. That would be contrary to our fiduciary duties as benchers. The only thing that we have agreed on sort of substance-wise is to make clear, because there's been a lot of, again, misinformation about the statement of principles. We've all agreed and made very clear that we have no intention of bringing back the statement of principles. I mean, I'm not a political animal, but it would be kind of strange and counterproductive to want to bring back something that was so unpopular with so many licensees, and which was ultimately repealed. Like, why would we want to bring that back? So that's not even an issue. And then, we're all also just committed to, good governance principles. And so I know that, lots of people want to talk about, and I'm happy to talk to you also about some of the, substantive issues that each bencher may have views on. But for me, really, this election, for good or bad, is not so much about the substantive issues as it is about the how. How are we going to run the law society? How are we going to govern? Because that's almost more important than the substance. Because if you look at the dysfunction of the last 4 years, if you look at the lack of preparedness, on the part of some benchers, not understanding what our statutory mandate is, that it's to the public and not to, we're not a professional organization representing the interests of lawyers. That's what the CBA is for, and the OBA. Our interest is to the public, which ultimately means making sure that lawyers have the resources they need, for example, to run good practices and be competent, et cetera. But the focus needs to be on the public interest. And so bringing silly motions that don't advance the public interest is a waste of everybody's time, and it doesn't reflect well on convocation. For example, bringing a motion to slash the budget of the Law Society by 25% without ever, proposing specific ways in which the money could be saved is not good, a way to govern. And so for me, it's the how that's important. And are people going to be serious? Are they experienced in terms of, governance models, budgets, and so on? And are they committed to collegiality and civility? And I think everybody in the coalition is on the same page with respect to those things. I pride myself on collegial governance as a faculty member, as a former associate dean, as somebody who sits on the advisory board for a major Muslim organization. So that's what I think is key. Once we know how we're going to govern, then we can get down to some really thoughtful, evidence-based discussions about the issues.
Okay, so let's explore that more than on the House side, right? I mean, what, I guess, are the sort of overarching principles of good governance, right, in terms of needs to be done? I mean, and again, from talking to some paralegal and lawyer bencher candidates, right, that they have all these great ideas, a lot of great substance, but how is that going to go through when you need 27 people to support it, right, in terms of the process? And again, from being on a board, right, that some of the work may come from committees, some of the work may come from the staff, right, and how it kind of all works together. So maybe you could tell me a bit more of how you see the how of the Law Society functioning.
Sure. And I mean, I'm doing this as an outsider, right? Because I've never been a bencher. I've never held any positions at the Law Society. But from the outside, what I see as important is what would be important in any big organization where there's a board of governors or a board of directors, which is making sure that you treat staff with respect. So apparently that's been a singularly, problematic thing in the last few years, is a very fractious relationship between some benchers and staff. Making sure that you have a diversity of views around the table at a board. I retweeted or reposted on LinkedIn an article that I read by a businessman who talked about he's a CEO, about what it takes to create a good board of directors. And one of the first things is having a diversity of views. It can't be an echo chamber. And so, again, the how is, I hope that people will see the Good Governance Coalition has a lot of diversity in terms of experience, different types of practice, different levels of seniority, and diversity with sort of a capital D, in the sense of many women, many racialized candidates. Why is that important? Because the more diversity that you have in all of those ways, the better the conversations, the more fulsome the analysis. That is true in the business world. There's empirical evidence which shows that companies who have diverse boards do better in terms of their bottom lines than those that are, pretty monolithic. So I think those are some features. It's really kind of common sense. It's respect for the people around you, understanding what your job is, and hearing a diverse set of voices on any particular issue.
I guess that gets back to kind of where we were talking initially about running collectively, right, as a coalition, and even just how the way elections are set up, right, in terms of, if you're out in Windsor, but people from Toronto are voting for you, and then it kind of creates this, again, it's supposed to be in the public interest, but then it's being done by lawyers for lawyers and paralegals for paralegals, that inevitably there's some sort of, well, I feel kind of loyal to my supporters, although I'm supposed to be loyal in my fiduciary duty to the public, right? So I know there's been talk, I've talked to some of the candidates about, is there a way to look at this a little differently, both with respect to sort of this two-party kind of system we have now that seems to be in place, and looking at changing things up, or any thoughts there on, in terms of the how, right, of how can we go about doing, even the fact that we have 53 people sitting on our board of directors seems kind of large.
It does. Yeah. So I hope you're wrong. I think in your question, you said something like, we seem to now have a two-party system. I really hope that that's not the case. I didn't mention earlier that one of the other differences between the coalition and the full stop slate is that we have explicitly committed to to doing electoral reform, to looking at how we can prevent future elections with slates, because I personally think we shouldn't do it this way, because it does then tend to create sort of a two-party system, which shouldn't be the case. The number of seats, it's a great point. Is 40 plus, lay benchers and all of that, is that necessary? I'd like to hear the arguments as to why. Is it just a remnant of history that we have 20 in Toronto, 20 outside Toronto? Is that truly, representation by population? I don't know. I'd like to look at the numbers and see. Your point about, people voting in Toronto for benchers from outside of Toronto, there is, of course, one seat in each region that gets elected just, if you get the highest number of votes in your particular region. But yeah, it's an interesting point. To be sure, there are going to be some regional differences, but I suspect that there are also going to be different needs, for example, that have nothing to do with regional geography so much as types of practice, year of call, and all of that. So, thankfully, last election, Tricia Lewis was elected. I think she was one of the youngest benchers ever elected at, 6 years out. There should be right, there should be benchers who aren't necessarily senior lawyers, who have experience working in community, for example, and who have that perspective to bring to bear. So as much as I know that we have a system now of regional representation, I don't know that reforming the election so that you only can get elected from your region is necessarily a good thing either. I don't know if that answers your question.
Oh, I guess it's certainly, again, something that can be discussed potentially down the road, right? Of looking at just some of this, right? In terms of, if, or I mean, maybe the answer is, well, we're okay with how it's being done, right? But again, let's maybe leave the how. I mean, I know you didn't want to talk as much about the substantive, but I'll give you a chance.
No, I'd love to talk about substance too.
Talk about some, what are the substantive issues that are the most pressing or the most important to you?
So access to justice for sure. And I know, it's a term that's gotten a lot of play time in the last, 10 years or so, 15 years. But it actually is, it's a really important topic. It's something that the Windsor Law School has institutionally been committed to since almost our inception. And it's what I've based my sort of professional, where my professional identity has been for a very long time. It's my area of research. I taught the course Access to Justice for several years. And now I created and run a clinic, the Class Action Clinic, which is the only one of its kind that I know of in North America, if not the world. And I see through the students who do the casework and Andrew Eckhart, who's our staff lawyer, how even in that context of a class action that itself is an access to justice mechanism, right? It's a legal procedure that's designed to overcome some of the financial hurdles that people have to bringing a lawsuit. Even there are significant access to justice barriers. So I guess I'm really attuned to the barriers, to some anyway, of the barriers that ordinary people face in getting to justice, however we define justice, getting to a remedy to their legal problem. And I'm all about, coming up with solutions. There have been many studies examining the problem from middle income Ontarians to low income Ontarians. The Law Society, I think, can play a really important role in lobbying governments for better legal aid funding, as well as coming up with some solutions to the barriers wherever they exist, and they exist at all. There's a whole bunch of choke points, as they call it in the academic literature, and it's important that we look at all of those. So that's something that I'm really enthusiastic about. I think I can also hit the ground running on questions relating to licensing pathways, because, I'm pretty steeped in legal pedagogy and experiential learning. There's a lot of, talk about, do we do away with articling? And if we do, should we be looking at the law schools to do experiential learning? And every time that sort of question comes up, I sort of chuckle, because the assumption is that law schools aren't doing experiential teaching. And I think, that's not true. There's a lot of experiential learning that's taking place in law schools all over the province, both in a clinical setting as well as in other settings, externships, that sort of thing. So that's where I think, we could have some really creative conversations about what we're going to do with articling. I think it's potentially on the chopping block, and I don't have a firm opinion right now whether to scrap or not to scrap. But what I do understand is that the current status quo is not tenable. There are too many students who struggle to get articling positions, too many students in articling positions that have none of the real training that I think articling is supposed to achieve. If you look at the list of learning outcomes that principals are supposed to ensure, right, that every student gets, it's really not feasible. And I always joke that, some people think the gold standard of articling is getting a court clerkship. Well, how many court clerks draft a will, right? Or do any kind of, business transaction? And yet articling principals, law firms are expected to, make sure that their students get that exposure. So it's not fair from a law firm perspective. And it's not fair for students, to have these inconsistent expectations depending on where you are. So I think all of that's a really important area of law society business that I would like to become involved in.
Perfect. So you had already addressed the question for students before already. So let's maybe go to the last question here, Jasminka, which is, why should the lawyers that are listening vote for you?
Well, I really don't like to sort of talk about myself. I did say before that I'm not a political animal. I would encourage people to look at my website, jasminkaforbencher.ca, which one of my kids helped me create, and one of my law students helped finish. I think, it's there, what I hope I can bring. I am deeply committed to collegial governance. It's something that I've read about. It's something that I hope I've practiced as a law professor and an associate dean. That's the way I conduct my classrooms. That I always tell students that everybody can make mistakes. We can make kind mistakes. I'm open to opposing views and to respectful dialogue. But it's just time to make Convocation an institution that works for everybody. So I hope I can be that positive voice, and that you'll see that that's been my experience and my way of doing things my entire life.
Perfect. So thanks again for taking the time to speak with me here today. Wish you all the best, and thanks for everyone for tuning in. Take care.
Thank you. Bye now.